When an accused spends years behind bars before a single charge is framed, what began as a legal process begins to feel like a sentence. This is the story of FIR 59/2020, the larger conspiracy case from the 2020 Delhi riots, and how delay, law, and administration combined to create prolonged detention. In late February 2020, protests against the Citizenship Amendment Act spread across the country. In northeast Delhi, a month to 6 weeks after these protests, targeted communal violence broke out. This violence was provoked by hate crimes and speeches. The 3 days of brute communal violence saw 53 lives lost, hundreds injured, whole neighborhoods burned. Several citizen committees and fact-finding teams later criticized the role of inflammatory speeches and media amplification in escalating the violence. On 6 March 2020, the Delhi Police Special Cell registered FIR 59/2020, alleging a larger conspiracy behind the riots. By September 16, 2020, the charge sheet ran to some 17,000 pages, weaving together speeches, WhatsApp messages, protest actions, and financial transactions into a single sprawling narrative. Mid-March saw the final acknowledgement by the Union government that the COVID-19 outbreak required intervention. Without consultation with states, unilaterally a lockdown was declared. A crucial decision, the prosecution invoked the Unlawful Activities Act (UAPA). A statutory provision, Section 43D(5), effectively raises the hurdle for bail. If the accused is charged under certain chapters, release on bail becomes the exception, not the rule. In practice, this hands enormous weight to the charge sheet at the bail stage, sometimes before any trial has truly begun. Many accused in FIR 59/2020, a group dominant by student activists, were first detained in earlier FIRs, sometimes released on bail, then re-arrested after fresh non-bailable or UAP additions. A widely reported example is Safura Zargar, granted humanitarian bail in June 2020 but then re-arrested as new offences were added to the roster. Defense teams repeatedly told courts that the prosecution's additions were response-driven, that non-bailable offences were grafted on to keep people detained. The judiciary, many argue, should have scrutinized that pattern early on. The case also suffered from judicial instability. After long stretches under certain judges, administrative transfers meant fresh benches had to reread volumes and, in some instances, rehear arguments. In May 2025, a routine transfer list moved ASI Sameer Bajpayee, who had begun charge arguments, out of the court. The Delhi High Court later revoked the transfer in June, ordering continuity because the case was at an advanced stage. "18 names featured in FIR 59/2020, mostly student activists alongside one politician. By mid-2025, only 6 had secured bail, while many others remained detained, some for 5 years or more, not because a guilty verdict was reached, but because the trial process had barely advanced. The report's blunt conclusion: when courts, prosecutors, and administration allow procedural delay to persist, imprisonment becomes the penalty by another name. The statutory architecture of UAPA, combined with administrative moves and prosecutorial strategies, has created a situation where the alleged crime remains untried while liberty is taken away. What our report asks for is straightforward. Courts must do a real surface-level assessment before denying bail under UAPA. High Court should fast-track long-pending bail pleas. Administrative transfers must not interrupt critical hearings. Lawmakers should consider statutory limits for prolonged custody in such cases. These are fixes to prevent the process from becoming punishment. The full report and the year-round tracking by Citizens for Justice and Peace documents not just this case, but patterns across many hate-driven incidents and prosecutions. To dig deeper, read the report on our website at cjp.org.in.